Good morning. We will call this hearing back to order, and we will continue with the company's case.
Good morning again, gentlemen. Mr. Sullivan, I'll start with you. Would you state your name and business address for the record, please, sir?
My name is John Sullivan, and my business address is 550 South Tryon Street, Charlotte, North Carolina.
Do you typically go by Jack, Mr. Sullivan?
Yes, sir.
And by whom are you employed and in what capacity?
I'm the Assistant Treasurer of Duke Energy Corporation and each of its regulated utility subsidiaries, including Duke Energy Carolinas.
Did you cause to be prepared 20 pages of direct testimony that was pre-filed in this docket?
Yes.
If I were to ask you the questions contained, and you better slip that a little bit closer to you to make sure you're heard. If I were to ask you the questions contained in your pre-filed direct testimony this morning, would your answers be the same?
Yes, they would.
Mr. Chairman, we'd ask that Mr. Sullivan's direct testimony be copied in the record as if given from the stand.
Mr. Sullivan's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Mr. Sullivan, did you also cause to be pre-filed in this docket 8 pages of rebuttal testimony?
Yes.
If I were to ask you the questions contained in your rebuttal testimony this morning, would your answers be the same?
They would.
Mr. Chairman, we'd ask that Mr. Sullivan's rebuttal testimony be copied into the record.
Mr. Sullivan's pre-filed rebuttal testimony will be entered into the record as though given orally from the stand.
And Mr. Sullivan, did you have one exhibit attached to your rebuttal testimony?
Yes.
Mr. Chairman, we'd ask that Mr. Sullivan's exhibit attached to his rebuttal testimony be introduced into the record as the next hearing exhibit.
Mr. Sullivan's exhibit will be entered as exhibit number 50.
Okay. Thank you, Mr. Sullivan. Mr. Hevert, would you state your name and business address for the record, please, sir?
My name is Robert Hevert. My business address is 1900 West Park Drive in Westboro, Massachusetts.
And by whom are you employed and in what capacity?
I am a partner with Scott Madden Incorporated.
Did you cause to be prepared 82 pages of direct testimony that was pre-filed in this docket?
Yes, I did.
Do you have corrections for that testimony?
No, I do not.
Okay. If I were to ask you the questions contained in your pre-filed direct testimony today, would your answers be the same?
Yes, they would.
Mr. Chairman, we'd ask that Mr. Hevert's direct testimony be copied in the record as if given orally from the stand.
Mr. Hevert's pre-filed direct testimony will be entered into the record as though given orally from the stand.
And Mr. Hevert, is there an attachment A to your direct testimony, and what is that, sir?
Yes, there is. There's an attachment A, which is
Your CV, a resume?
It is my CV, resume, and testimony listing.
Okay. And then you've got 7 exhibits, is that correct?
Yes, that's correct.
Okay. Mr. Chairman, we'd ask that Mr. Hevert's attachment A and 7 exhibits be introduced as the next hearing exhibit.
Mr. Hevert's attachment A and 7 exhibits will be entered as hearing exhibit 51.
And Mr. Hevert, have you also caused to be prepared 101 pages of rebuttal testimony that was pre-filed in this docket?
Yes, I have.
Do you have a correction to the rebuttal testimony?
I do. I have one typographical error, which is on page 32, and And this would be on lines 15 to 16. Obviously, the reference to Dr. Woolridge should be to Mr. Parcell. It's a small business, but not that small.
Okay. With that correction, if I were to ask you the questions contained in your rebuttal testimony that was pre-filed in this docket, would your answers be the same?
Yes, they would.
Mr. Chairman, we'd ask that Mr. Hevert's rebuttal testimony be copied in the record as if given from the stand.
Mr. Hevert's pre-file rebuttal testimony will be entered into the record as though given orally from the stand.
And Mr. Hevert, are there 16, no fewer than 16 exhibits attached to your rebuttal testimony?
Yes, there are.
Mr. Chairman, we'd ask that Mr. Hevert's exhibits be introduced into the record of the case.
Mr. Hevert's 16 exhibits will be entered as hearing exhibit number 52.
Going back to you, Mr. Sullivan, would you summarize your testimony for the commission, please?
Sure. Start by saying good morning, Mr. Chairman and members of the commission. The purpose of my direct testimony is to address Duke Energy Carolina's financial objectives, capital structure, and cost of capital. I also discuss the current credit ratings and forecasted capital needs of the company. Duke Energy Carolinas faces substantial capital needs over the next several years. The company competes for capital in the open market and must appeal to debt and equity investors to attract the capital it needs. Investors have a variety of investment opportunities available to them and require a return commensurate with the risk they incur. They will invest elsewhere if they feel the expected return provided by a company is inadequate, and lower credit quality weakens a company's attractiveness as an investment opportunity relative to companies with higher credit quality. For this reason, it's critically important that the company maintain strong investment-grade credit quality to demonstrate financial strength and flexibility and ensure access to capital on reasonable terms. Investors, investment analysts, and credit rating agencies regard constructive regulation as one of the most important factors in assessing a utility company's financial strength. These stakeholders want to feel confident the company operates in a stable regulatory environment that will allow the company to recover prudently incurred costs in a timely manner and earn a reasonable return on investments necessary to meet the demand, reliability, service, and environmental requirements of its customers and service territory. The rating agencies believe Duke Energy Carolinas operates in a generally constructive regulatory environment that supports long-term credit quality. However, the rating agencies have identified a number of challenges the company faces in maintaining its credit ratings, including elevated capital expenditures, regulatory lag, and tax reform. My direct testimony supports Duke Energy Carolina's proposed capital structure of 47% long-term debt and 53% equity. This proposed capital structure is optimal for Duke Energy Carolinas as it introduces an appropriate amount of risk due to leverage while minimizing the weighted average cost of capital to its customers. Approval of the proposed capital structure will help the company maintain its credit quality. Witness Hevert indicates that the company's cost of equity capital is in the range of 10.25% to 11% and recommends an ROE of 10.75%. The company fully supports Witness Hevert's testimony and analysis. However, as a rate mitigation measure and in recognition that a rate increase may create hardships for customers, the company has proposed rates to be set with an ROE of 10.5%. Approval of the company's request in this case will support its financial objectives by allowing timely recovery of its investments in plant and equipment, providing sufficient cash flows to fund necessary capital expenditures, and service debt, and will provide a fair and reasonable return to equity investors. The purpose of my rebuttal testimony is to respond to portions of the testimony of ORS witness Parcell. In my direct testimony, I advocated using Duke Energy Carolina's cost of long-term debt of 4.63%, which was the actual rate calculated as of December 31st, 2017. Mr. Parcells' direct testimony recommends updating the cost of long-term debt to 4.44% based solely on 2018 debt issuances utilized in part to refinance 3 long-term debt maturities in that year. In my rebuttal testimony, I explained that the company does not oppose updating the cost of long-term debt, but recommends a rate of 4.53%, which reflects additional updates that did occur in 2018 that Mr. Parcells did not take into account, and is the actual cost of debt as of December 31st, 2018. Next, I examined the detrimental impacts to the company of Mr. Parcells' recommended 9.3% ROE and the overall revenue requirements proposed by the ORS. The ORS's recommendation does not take into account the adverse impacts the reduced cash flows would have on credit quality. These impacts could be severe to the detriment of the company's credit quality and the interests of its customers. The company's regulatory capital structure and allowed ROE are key components in maintaining the company's current credit ratings and its overall financial strength and stability. This concludes the summary of my direct and rebuttal testimony.
Thank you, Mr. Sullivan. Mr. Everett, would you summarize your testimony, please?
Yes, thank you. Mr. Chairman, members of the Commission. The purpose of my direct testimony is to estimate the company's return on equity, sometimes referred to as the ROE, or cost of equity. Although my testimony necessarily discusses the financial models used to estimate the cost of equity, I also address other issues that are important in developing ROE recommendations. In particular, I address capital market conditions and the effect of those conditions on the return investors require to commit their equity capital to equity securities. My testimony also addresses business risks facing utilities such as Duke Energy Carolinas and the importance of maintaining a financial profile that enables the company to access the capital markets at reasonable cost rates when and as needed. Based on those analyses, I recommended a range of 10.25% to 11% with a specific ROE recommendation of 10.75%. The cost of equity is the return investors require on equity investments of comparable risk. Like the interest paid on debt, the return on equity is a cost set by investors in competitive capital markets. Unlike the cost of debt, which can be observed in the interest rates required by investors, the cost of equity is neither directly observable nor contractually defined. Estimating the cost of equity, therefore, requires the careful application of various financial models to observable market data and considered judgment in determining where the cost of equity falls within the model's range of results. In my direct and rebuttal testimony, I discussed the fact that all models used to estimate the cost of equity are subject to their own sets of assumptions and constraints. I also discussed the effect of federal intervention in the capital markets and the challenges created by that intervention for estimating the cost of equity. I note that as market conditions change, the ability of each model to reasonably estimate the cost of equity also changes. That is, a model that may have produced reliable results under one set of market conditions may become less reliable under a different set of conditions. My testimony explains that the Federal Energy Regulatory Commission, along with state regulatory commissions, have noted the tendency of the discounted cash flow model to produce unreliably low results and the importance of looking to other methods to determine the cost of equity. Those methodological considerations, together with various business and capital market risks, support my view that a reasonable range of ROE estimates is from 10.25% to 11%. My rebuttal testimony responds to the opposing witnesses' recommendations as they relate to the company's cost of equity and ORS's recommendation to disallow the return on certain deferred costs. There are several areas in which I disagree with the opposing witnesses' analytical methods and conclusions, and I address those issues in detail throughout my rebuttal testimony. In summary, none of their arguments or analyses has caused me to revise my conclusions or recommendation. Regarding ORS's recommendation to disallow a substantial portion of the company's proposed rate increase, including about $470 million of its deferred coal ash management costs and the return on certain accounting deferrals, I note that if adopted, those recommendations would be seen by investors as a departure from the constructive regulatory environment that has prevailed in South Carolina. My testimony addresses the importance of a consistent and constructive regulatory environment to investors and the adverse consequences of a sudden departure from that environment. I note that if the financial community did perceive such an adverse change, the company's ability to efficiently raise the capital needed to fund its utility operations would be compromised. As to ORS's recommendation to disallow the return on certain deferred costs, I note that ORS points to such deferrals in support of its 9.3% ROE recommendation, but would eliminate the return on certain of them. I further note that whether they are considered operating or capital costs, the company has expended the cash associated with those costs. Unless it is unable to earn a return on those deferred costs, the company will see a loss of value, and investors will see an increase in risk and will require higher returns. Thank you, and that concludes my summary.
Thank you, gentlemen. Please answer any questions that the parties of the commission.
Thank you. Mr. Cully.
Thank you, Mr. Chairman. Make sure we're good and close here. And good morning, Mr. Hebert. My questions are going to be for you.
Good morning.
And I'm going to take a wild guess. If you hear me say, my name is Thad Cully, I represent Vote Solar, you probably know exactly what page we're going to turn to. Would that be accurate?
My guess is it's going to be in my direct testimony.
That's right. So to not hide the ball, page 51 of your direct, in a section discussing business risk and distributed energy. Okay. So let me just first ask, are you aware of the Edison Electric Institute? You're aware of that as a organization?
I am, yes.
And have you heard of a report that was published by EEI in 2013 by a gentleman named Peter Kind called Disruptive Challenges?
By Peter Kind, K-I-N-D?
That's right.
I believe so, only because I've known Peter for quite some time. But I do not recall that report specifically.
Okay, good. Well, at least we have a character witness available for this. Well, you cite several financial reports in your direct testimony, I believe around page 56. And would you agree that all of those reports are subsequent to January 2013?
Yes, I agree with that. Okay,
and are you aware that Mr. Kind published this, I think we could call it safely, a seminal piece on DG and business risk in January 2013? Would you accept that subject to check?
I would accept that, yes.
And are you aware of what Mr. Kind's thesis about distributed generation and the risk it poses is, as that relates to loss of revenue for the utility and the so-called death spiral? Are you familiar with that line of argument?
Not as I sit here, no.
You're not? Okay. Now, in including distributed energy in your testimony and discussing net metering, is your contention that revenue erosion is one of the business risks that should be considered?
It's a good question, and let me sort of put it all in perspective for you. There are several risks that I consider, several factors that I consider in establishing my recommendation. My range, as I said earlier, is 10.25% to 11%, and the specific recommendation is 10.75%. If you look at the midpoint of the range, it would be 10.625%. So in aggregate, the risks that I discuss, including flotation costs, including the issues we're here talking about right now, including capital market risks, amount to about 12.5 basis points. So yes, I do consider them, but as to their collective and individual consequence, I would say it's about 12.5 basis points.
Okay, got you. Thanks for that clarification. Now, this is going to be a high number, but can you give us a number of approximately how many times you've testified on ROE before public service commissions?
I've submitted testimony about 200. On rate of return, probably about 200 times.
About 200 times. And would you know off the top of your head how many of those times you addressed distributed generation within your testimony as a risk?
I would not be able to say off the top of my head, but it's certainly less than 200.
Less than 200 is I think, safe to say. Would would you accept, subject to check, at least in my research, the only instances I have found of your testimony, including this, would be National Grid in Rhode Island, Duke Energy Carolinas in progress in North Carolina in last year's rate cases, and a 2016 Duke Energy Progress South Carolina rate case. Are there others I'm missing in that list?
Again, as I sit here, I could not say, but I will accept that.
Okay. And would you agree that there are jurisdictions you've testified in that have far greater penetration of solar, that is, far greater percentage of solar adoption per customer?
Yes, I think that's probably fair to say as well. The thing, one issue that sort of strikes me in these cases, again, is the extent to which there's investor recognition of the issues. But as to your point of, is there greater solar penetration perhaps in other jurisdictions, I do not disagree with that.
Okay. I have no more questions. Thank you, Mr. Hedford.
Thank you, Mr. Cully. Ms. Thompson or Ms. Ferguson? Ms. Lee? Mr. Elliott? Ms. Grunman? I'm glad I didn't miss you on my list that time.
I wouldn't have let you miss me this time. Good morning, gentlemen. My name is Carrie Grunman. I am here on behalf of Walmart. I have questions for both of you, but I'd like to start with Mr. Hebert. Mr. Hebert, can I draw your attention to page 4, line 17 of your testimony, your direct testimony? And I just want to kind of go through this step by step. I think you probably covered it in some of your opening statement, but you have proposed a range for the cost of equity of 10.25 to 11% in this proceeding and have proposed the set point at 10.75%, correct?
That is correct, yes.
And you understand that the company has, for purposes of its application, agreed to a lower ROE at 10.5% from what you propose in your recommendation?
Yes, I understand that.
And am I correct that to arrive at both your proposed range and ultimately the specific point that you propose, that you relied upon what I'm going to call 3 primary models, the DCF, the CAPM, and the bond yield risk premium analysis?
Yes, that's correct.
And then with the DCF, you actually modeled 2 different types of DCF analysis. Is that fair?
I did.
So I want to start with the DCF analysis. Am I correct that one of the inputs to that analysis is a projection on earnings per share?
You are correct, yes.
And does the earnings per share calculation, does that also flow through and get used then in your CAPM projection?
Not directly, no. And just to clarify, the earnings per share projection rate is the growth rate component of the constant growth discounted cash flow model, and it serves as the basis for calculating projected dividends in the multi-stage model. It is not a direct input to the capital asset pricing model.
Is it a piece that it goes in as one of the components of the CAPM?
Projected earnings growth?
Yes.
No, it is not.
Does the CAPM rely upon a projected Treasury bond yield?
The CAPM relies on projected Treasury bond yields. Let me go back to your other question. When you talked about the CAPM, and I want to clarify because, as with all models, there are several layers to it. There are 3 principal components of the capital asset pricing model: the risk-free rate, the beta coefficient, the market risk premium. The market risk premium is the difference between the expected return on the market and the risk-free rate of return. So if your question went to that second level, if your question went to our projected earnings growth rates used in calculating one of the components, then earnings growth rates projections are used in calculating the market risk premium.
That, in fact, was my question, which is I should have asked it better, which is to say that the earnings growth is part of the market risk premium in the CAP-M modeling.
I think we're now on the same page.
I appreciate that correction. Thank you, Mr. Hebert. And then going down to your bond yield risk premium analysis, is the earnings per share also part of calculating the market risk premium for this particular model?
No, it is not.
Okay. I think you've just testified in response to some questions from Mr. Culley that you have testified a number of times, around 200 on rates of return in various jurisdictions. Is that correct?
Yes, my total testimony listing is about 250 times. Several of those have been for issues aside from rate of return, so I will guess about 200.
Subject to check. I'm not going to check today.
Tomorrow?
Maybe tomorrow.
Okay.
So would you say it's fair that you fairly commonly in your testimony that you offer in these other jurisdictions rely upon your calculations using the discounted cash flow, the CAP-M, and the bond yield risk premium analysis?
That is fair to say. It's also fair to say that depending upon the circumstances, depending upon the jurisdiction, depending upon issues raised by interveners, we may apply other methods as well. A variant of the capital asset pricing model may be used. Expected earnings may be used. So my analyses are not necessarily limited to those three.
Do you know, as you sit here today, well, let me back up. You testified on behalf of Virginia Electric Power Company. I'm going to refer to them as Dominion since I think that's how most people from Virginia refer to them. Okay. In their 2017 ROE proceedings before the Virginia State Corporation Commission.
So this would be for one of the limited issue rate riders?
Absolutely.
Yes.
But you also understand, though, that in Virginia, those limited issue rate riders are also going to be used more globally to set the rates of return when they have their upcoming triennial proceedings.
I'm sorry, can you restate that question?
That's okay, I'll move on. But you're familiar with the 2017 proceeding, PUR 2017-00038, and I'm going to put it up on the Elmo. It was distributed as Exhibit 28 yesterday, and I apologize, Mr. Hebert, but I distributed all my copies. If you'd like to see this one, I can show it to you.
That's fine. Thank you.
Does this copy of the front page of the final order refresh your recollection that you participated as an expert on behalf of Dominion in this proceeding?
My recollection did not need to be refreshed.
Mr. Hebert, have you reviewed this final order from the Virginia Commission?
Not recently, but I have read it, yes.
And are you, so you're familiar then with the Virginia Commission's criticisms of your analysis?
I'm familiar with their observations, yes.
And so I want to go through this order because I just want to understand, primarily what I'm trying to understand is how similar the modeling that you conducted in this proceeding is similar to the type of modeling that you conducted in the 2017 Dominion proceeding.
Sure, happy to do that.
And so in the Dominion proceeding, and I have some highlights and notes, but in that proceeding, you proposed an ROE range of 10.25 to 10.75%.
Yes, that's right.
And you're aware that while the commission awarded an ROE of 9.2%, the Virginia Commission found that the market cost of equity for Dominion was at the midpoint range of 9.0%.
I'm aware of that, yes.
And turning to the very bottom of the page, that last sentence, it reads, as the Commission has previously stated, using only earnings per share as the measure of long-term growth results in unreasonably high growth rates that upwardly skew results, and that was with respect to your DCF modeling. Are the earnings per share referenced in that sentence of the order the similar similar to the input used here on the dividend growth in your DCF modeling in this proceeding.
It is, and I certainly appreciate that is what the commission in Virginia said. There certainly are other commissions around the country that have come to different conclusions, but as to your question, I agree with that.
I want to come back to that statement, but I want to come back to it in just a minute.
Good.
So then turning to the sentence that begins, moreover, the company's capital asset pricing model analysis is also flawed. And one of the reasons they give for that is the use of projected 30-year Treasury bond yields.
Yes.
Does your CAP-M modeling here rely upon projected 30-year Treasury bond yields?
Not exclusively.
But it does rely on it in part.
I think we need to clarify.
Please.
The model, when I run it, will run different scenarios, one based on a recent average of rates, one based on a risk-free rate, which is what we refer to as a near-term projection, so the expected 30-year Treasury yield, say over the coming 2 or 3 quarters, and then a longer-term projection. So the projected Treasury yields would be 2 of the scenarios, but not exclusively the only scenarios.
Understood. I want to go back to your direct testimony, and I want to go back specifically to some of the modeling that you did. Turning to page 25 of your direct testimony.
Okay, I'm there.
Mr. Hubbard, I just want to make sure that I understand what I'm looking at. This is the constant growth DCF results, correct?
It is.
And so does this show if we were to rely solely upon this modeling, an ROE range of between 8.36 and 10.22%?
I think that's fair. Yeah.
And then if you could turn to page 34 of your testimony.
I'm there.
Looking at the multi-stage discounted cash flow, this reflects an ROE range of between, I believe, 8.90 and 9.47%.
It does.
I would like to skip, for the time being, your CAP-M, and I'd like to go to your bond yield at page 41.
Yes, I'm there.
And am I correct that that shows, upon your modeling, a range of between 9.97 and 10.27%?
That's correct, yes.
So then let's go back to your CAP-M, and I believe those results are on page 38 of your direct.
They are.
And so your CAP-M produces a range of between 8.75 and 12.24%, correct?
Correct.
And so is it fair to say that the only modeling that you have conducted as part of this proceeding that supports the ROE range that you have asked this commission to adopt is the CAP-M analysis concluded at page 38 of your testimony?
I don't know that I'd necessarily agree with that. I mean, if you go back to Table 2, the constant growth discounted cash flow results, you're at 10.22%, 3 basis points from the lower end of the range. So,
But 10.22 is still below your range.
It is below the range, but you bring up a great point, which is the application of judgment that's necessarily required here. In my view, when you look at all of the issues, all of the risk, all of the volatility in the market, am I willing to draw a bright line between 10.22% and 10.25%? No, I'm not.
Would you agree with me that all 4 of your models, though, do have an overlap point? And I apologize, I think that's actually incorrect. I think the multi-stage DCF only goes as high as 9.47.
Right, so
none of them have an actual overlap point, is that correct? But they all propose results with a 9 ROE as the first number.
I'm sorry, I'm just not following your question.
That's okay, Mr. Hubbard. It was probably a poorly worded question on my part. Mr. Hebert, I think earlier what you said is that you, in response to us talking about that 2017 Virginia order, that you understood the Virginia Commission's position, but that other commissions had found differently. Is that, I probably not said it exactly, but is that fair?
I think that's a fair characterization, yes.
Can I draw your attention to Attachment A to your direct testimony? I believe that is your listing of cases.
Sure.
And I'm going to disclose to you that what I'm going to do is I'm going to pass around an exhibit where I have gone through your Attachment A and I have identified, as best as I can, what I believe to be cases where you have testified, say 2015, 2016, 2017, 2018. And so I can go through those. I've highlighted them on an Attachment A, but what I'd like to do at this time is have marked for the record an exhibit that I'd ask to pass.
We'll mark it as Exhibit 53. Yes, sir.
Before you actually admit it, I'd like to know how the witness reacts to it.
We're marking it right now.
Mr. Hebert, I will represent to you that this document is a document that I prepared. It lists cases that were disclosed in your Attachment A as cases where you had served as an expert witness. I have then, from those cases, pulled the direct testimony that you offered in those proceedings to produce the range of proposed cost of equity to the extent you propose one, as I believe there are some cases where you do not propose a range, but you propose a singular point. And then to the extent you actually identify an ROE, I've then identified it. I have also, from those same proceedings, pulled the final order from those proceedings and have identified the ROE that was adopted by that commission. I have reflected the delta between the ROE awarded and the ROE that you propose. And then I have indicated in the final column whether that was a stipulated decision or a litigated decision.
Can you tell me how this differs from what I believe was our response to ORS 318?
Honestly, I cannot. I don't, as we sit here today, have that. But
we were asked this specific question, and I provided that specific response, so I'm not entirely sure how this corresponds with that response. But anyway.
I don't. Do you have a copy of that discovery response? I don't actually have a copy of it. I'm happy to evaluate the difference to the extent you think there might be one, but I'll disclose to you that these were cases that I specifically identified, choosing ones that were more recent. And I'll draw your attention back to your Attachment A.
Okay.
As an I'll just give you an example. For Delaware Public Service Commission, I have provided the ROE as determined in docket number 170977 for Delmarva Power and Light, as that is a decision that was rendered most recently in August 2017 for the electric utility as opposed to the gas. But I have not provided, although it was in 16, the prior decision in 16. So I'm attempting to identify the more recent decisions. And so, Mr. Hebert, I do actually have here, to the extent you're not sure that you can agree with the numbers that are there, I have copies of the front page of your direct testimony in each of those proceedings with your recommendation, as well as the front page of the final order with the proceedings. So I guess my question to you is, do you agree, subject to check, that the numbers contained in those columns are accurate?
Well, I don't know. And the reason I say that is because there are times when the recommendations will change from direct to rebuttal testimony, so that the eventual recommendation may not be what is included in the direct testimony. So As I sit here and look at these, I'm sorry, but I just can't really confirm whether that's the case for any of these.
Well, so there are situations where in your subsequently filed rebuttal testimony, you may have altered your ROE recommendation. Is that correct?
Correct.
But you do not disagree that this was the recommendation that would have been set forth in the direct testimony proposed in each of the proceedings set forth in the exhibit.
Again, I think I would have to take that subject to check.
For purposes of time and the commission's time, I have copies of all of those today.
Okay.
And I'm happy to go through each one with you here on the record, but if you're happy to agree, subject to check, that these were correct, I think it's just the most expeditious way to move forward.
I think we can all agree with that.
And so, Mr. Hubbard, as I look at this attachment, again, a subject to check, since you can't do the math here, would you agree with me that the mean ROE awarded for the proceedings set forth in this exhibit is 9.59%?
So the mean, well, it looks like it's 9.59014 going on and on.
Absolutely. 9.59, even if we rounded, it would remain 9.59.
But what I would say is, as I think you probably noted, or at least alluded to, many of these are distribution-only cases. They're not vertically integrated electric utilities as we have here. So
I'd be happy to have you go through for the record.
if I could just finish.
Oh, sorry, I apologize.
My point simply is that if you were to take information regarding the 9.59%, I think we would have to understand that many of those are distribution-only companies. That's my only point.
Do you want to go through for the record and identify the ones that you believe to be distribution only?
I'd be happy to.
Okay.
Let's start from the top. Connecticut, Delaware, the D.C. cases, the 3 Maryland cases, the 2 Massachusetts cases, New Hampshire, New Jersey, New York, Rhode Island, and let's see the Texas cases. Well, of course, the last case is a limited issue rate rider case, the Virginia case.
Understood. But that's all of them.
I believe that's right, yes.
So we could exclude these cases and then recalculate that average.
I don't know the purpose for which you're using the average. I just wanted to make that clear.
But you agree that we could add up the remaining commission-adopted ROEs, divide by the total number of results, and come up with an average for what you have described as vertically integrated utilities?
We could do that, yes.
I'd like to ask that another document be marked.
We'll mark this as Exhibit 54.
Mr. Hubbard, I'll represent to you that the cases listed here are cases that were pulled from Exhibit 53 and are cases that I believe were where the ROE was determined as the result of a litigated proceeding.
Okay.
Can you review this list and let me know whether you, I guess, disagree as you sit here? And I understand I'm asking you to reach back into what may have been many cases over the last few years.
I would say the Indiana-Michigan case you have as litigated. I don't know that the rate of return was litigated. The reason I say that is I don't remember being at hearings there.
Okay.
And these hearings are so special, I usually remember them.
We try very hard to make them special.
I appreciate that.
Other than that case.
Beyond that, I think that's, yes, I do recall those.
Okay, so the remaining of the cases, and they're all subject, obviously, to the caveat that you gave me in response to Exhibit 53, that some of these cases involve distribution only and not vertically integrated utilities. And I think that includes Connecticut, D.C., maybe Maryland, Massachusetts. Is that fair?
Yes, and I'm just hesitating here for a minute. The one that strikes me, and again, all of these I would take subject to check, but the 9.5% in Maryland for Delmarva seems a bit low, but again, I'll take that subject to check.
If that's something you have a question about, I can pull that.
That's fine. We'll go with this.
Okay. And obviously, we'll take out for the time being the Indiana-Michigan. You'll see that it shows that that case had a basis point difference between your proposed ROE and the commission adopted of 70 basis points.
Well, you bring up an interesting point there. Well, I appreciate that you put in the proposed range because my recommendation is, of course, a range. I give a point estimate because we have to for the purpose of setting the revenue requirement, but I always give a proposed range. So there, the adopted ROE was within 10 basis points of the range, as was the National Grid case, and the NSTAR Electric case, of course, was within my range. So my point is that you look at the difference between the proposed ROE and the adopted ROE.
But for purposes
there's also, my recommendation includes a range.
But for purposes of my math, you don't disagree that my math, subtracting your proposed ROE point from the commission adopted ROE, you don't disagree that my math is correct.
I don't disagree with that math, but I do not agree that your math fully reflects my recommendations.
I understand. I understand that distinction, but from a math perspective, you agree that even including the Indiana-Michigan case, which I think you would agree would likely make that number higher, that the average point difference is 86.7 when we are comparing your proposed point ROE from the commission-adopted ROE, subject to check.
I would, and again, two observations. One is my recommendation is a range, and second is if your question goes to, is this somehow unique to me, I don't think it is.
No, I guess my question is that if we assume that on average commissions adopt an ROE that is 86.7 points less than the point ROE that you propose in a proceeding, then in this case, that should lead this commission to conclude that an ROE below 9.9 would be appropriate.
You have a lot in there, and I'm fairly certain I do not agree with your conclusion.
I'm fairly certain you would not.
No, I don't think, first off, this is a limited set of jurisdictions. We have to look at the fact that some of these jurisdictions are considered, let's just say, not very credit supportive either by the rating agencies or by regulatory research associates. Connecticut, the District of Columbia, Maryland, all among the lowest rated jurisdictions. So if you're going to take some information from this chart, I think you also need to take into account how the financial community views those jurisdictions in terms of credit supportiveness. The second, this is, of course, a subset. And third, as I mentioned earlier, my recommendation goes to a range, not necessarily to a point estimate. And fourth, I think if you're going to extrapolate this 86.7 basis points, I think that's a fundamental error. I don't think extrapolation is a proper method to use in this case.
Mr. Hebert, then answer this question for me, whether or not we extrapolate. Going back to Exhibit 53,
Yes.
Can you identify how many cases set forth on Exhibit 53 where the commission listed adopts either the range that you propose or the ROE point that you have proposed?
Sure. Certainly Florida was within the range. We're going to go back to the bright line issue again. You see you've got the Indiana-Michigan case there that's within 5 basis points.
I want you to be very clear. I want you to identify only those cases where it is actually within your range. Not close. We're not playing horseshoes. Only those cases where it's actually within your range.
I took you for someone who'd like horseshoes.
You would be right.
So we certainly have the Florida Power and Light case. We have the NSTAR Electric case. I guess those are them. Those are the two.
So 2 cases out of that total list where they've adopted your proposal. And going back to Exhibit 54, you would agree with me that we could recalculate Exhibit 54 and we could take a look at the difference between the bottom end of your range and the commission adopted ROE. That would likely be a smaller number than 86.7, wouldn't it?
It would be.
And but then if we were going to subtract that from an ROE proposed in a proceeding, you would subtract. In my case, I've obviously done the subtraction from the ROE point that you propose. But if we were going to do it based upon your range, we would subtract from the bottom of the range, correct?
Correct. And let me go back to a point that I made in my opening statement regarding the complexity of estimating the cost of equity. I do not think an investor would look at this type of information and draw the types of conclusions you've drawn without looking at things such as the jurisdictions in which these decisions were made, the extent to which the community considers them supportive or not. I think you would look at differences in market conditions. I just don't think that the financial community would undertake this type of analysis. And my point is important, I think, because what we're here to do is to try to understand how the financial community looks at investments, looks at the cost of equity.
So is it your position then that in order for investors to appropriately look at the company, that they need what would amount to the highest ROE awarded anywhere in the country since 2016 other than Alaska?
Make sure you stay in front of your microphone because they're
Absolutely.
telling me they can't hear you.
I'm sorry, can you one more time?
I believe that the highest ROE awarded in recent times is the 11.95 ROE that was awarded in Alaska.
I think that's correct, yes.
And then I believe the next highest ROE, which correct me if I'm wrong, is the 10.55 that was awarded in Florida in 2016.
We're not including the 10.95 at Georgia Power, I'm guessing.
I'm sorry, my caveat was since 2016.
Oh, I apologize. I did not hear that. I think that's probably right.
And so to the extent the commission were to accept your 10.75, it would be the highest ROE awarded in the continental United States since 2016.
3 points on that. First, yes, it would 10.75 would be high. Well, it would be at that point that you described. Second, 10.25 would not. And third, 10.5 certainly would not be.
And you have discussed a couple of times here investor expectations and the credit, I think the way that investors view the jurisdiction. I know I've phrased that poorly, but you recall your earlier testimony on that point.
Yes, I think it's fair to say that the supportiveness, the predictability, the consistency of regulatory policy, regulatory decisions is quite important to investors, to the financial community generally.
And if we were to turn to your rebuttal testimony for a moment, directing your attention to page 89. I'm normally never told I'm not loud enough. page 89 is where you are addressing and responding to some of Walmart witness Tillman's testimony, correct?
Yes, that's right.
And is it fair to describe what you did both in Table 5 and your rebuttal exhibit RBH 16? Is that you took data that was provided in Mr. Tillman's testimony and then added information from RRA about the credit supportiveness of the jurisdiction?
I think what I did was went back to...
Oh, you went to RRA, but you pulled your own data.
Correct.
Okay. That's a helpful distinction. So can I draw your attention to Exhibit 16? I think it's the very last 2 pages of your exhibits that were offered in this particular rebuttal testimony.
It is. Yes, thank you. I'm there.
And I'm going to do my best. I have zoomed in here to the bottom of the second page of Exhibit RBH 16.
Okay.
As I understand what you have done is you are relying upon jurisdiction rankings that are calculated by Regulatory Research Associates, yes?
You say calculated by, I'm relying on how Regulatory Research Associates ranks each jurisdiction, if that's your question.
It is. And then, so what RRA uses is above average, average, and below average rankings, yes?
Right, and as I note in this exhibit with tiers within each
And you've
broad
gotten to my
category.
next question, which is within each category, there's 3 rankings of above average, 3 rankings of average, and 3 rankings at below average.
Right, and what Regulatory Research Associate says is they try to keep roughly an equal number of jurisdictions within each of the 3.
Okay. So I have a couple of questions
Okay.
that relate to your exhibit. But I'd like to talk about your exhibit in the context of what you've said in your testimony.
Okay.
So on page 89, you claim that South Carolina is ranked average 3.
Yes.
And you describe that as falling approximately in the bottom third of the 53 jurisdictions ranked by RRA.
Right.
So I'm a little confused
Okay.
because if I look at your Exhibit 16, it appears as though you have ranked 71 different cases. And so I assume that means that there are some cases that double up in jurisdictions.
I'm sorry. Can you repeat that? I'm not following.
Absolutely, because I'm not sure I follow either. Your testimony, lines 21 and 22 at page 89, says that South Carolina falls approximately in the bottom third of the 53 jurisdictions ranked by RRA.
Yes.
However, Exhibit 16, upon which you rely to draw that conclusion, provides information about 71 cases.
Right.
How am I supposed to identify who goes where?
By looking at the exhibit. I mean, if you, in each case, we show the jurisdiction and the RRA rank. So if your question is because there are 53 jurisdictions, should there be 53 cases? No.
So does RRA create the designations that you have there at the top of page 2, which I'm going to call top tier, middle tier, bottom tier? Or are those your breakdowns?
Let me be quite clear. If you look to the 4th column to the left, the RRA rank, that is the rank that Regulatory Research Associates applies to each commission.
I understand, but my question is...
And then when then RRA speaks to the fact that they try to keep roughly an equal number within the 3 broad jurisdictions. So what I have done is to put them in 3 tiers, the top tier, the middle tier, the lower tier, according to those rankings. So,
Well, let's back up. I kind of want to walk through this just a little bit more
Sure.
piecemeal. So you created the designation top tier, middle tier, bottom tier, correct?
could have called it top third, middle third, bottom third. But
Absolutely. And had you done that, I would have expected to see approximately 1/3 in the top third, approximately 1/3 in the middle third, and approximately 1/3 in the bottom third. That would seem logical to you, wouldn't it?
I don't see why you would do that. It depends on what company files a rate case. It depends on which jurisdiction they're in. There's nothing to say that in any given period of time, the jurisdictions will be evenly distributed across RRA's rankings. So, no, I don't see why that would be the case.
Well, you made the decision, didn't you, in determining what counted as top tier to include average one in the top tier, didn't you?
Sure, but so I think what you're saying is that over and in any given period of time, if we look at rate cases that were filed, necessarily they will be distributed according to RRA's rankings, but that's just not true. You can have several cases filed in one jurisdiction that has one ranking, and therefore you'll have a lot in one tier and not in another tier. So I disagree with your premise that in any period they should be evenly distributed.
Well, that raises an interesting question, doesn't it? So if we go to page 1 of your exhibit, I think you've only identified one case from South Carolina.
So that would be the cases that were listed by Regulatory Research Associates, right?
Well, I apologize. I'm having a tough time bringing this up since it's so small, but I'm going to direct your attention to about a third of the way down on page 1. It says South Carolina. The only case that you've listed here is Duke Energy Progress, LLC, case number D 2016-227E. If you'll review the sheet and just confirm for me that that's the only South Carolina case listed there.
Again, I don't mean to quibble, but when you say that I listed, these are the cases provided by Regulatory Research Associates. So these are the cases that RRA reported, if that's your question.
It's not. It's not. You put this exhibit together and you've offered it, yes? And the only case that's contained here from South Carolina is the one that is identified as the 2016 Duke Energy Progress rate case. Do you agree as we look at Exhibit 16? It's just a simple yes or no. Either South Carolina is listed once or it's listed more than once.
South Carolina is listed once because that's how many times Regulatory Research Associates reported it.
Understand. So understand. It should be a simple yes, because then my next question is you don't have listed here the recent proceeding for SCE and G.
That's right. You'll see if you go to page 2, on the date column, they're listed chronologically. So
I agree with that, but I believe the order in SC.
I'd like to finish
Absolutely,
if I could.
sure.
And y'all, Miss Tackett is great at this court report and stuff, but she can only say a word, one word at a time. So if y'all will not talk over each other, it will make for a much cleaner transcript. Thank you.
Thank you, Mr. Chairman.
So if you look at the last date, because these cases are listed chronologically, excuse me, that's January 9th. So I agree with you, yes.
Do you know when the final order was issued in the SCE and G case?
That would have been in February.
Turning back to page 1 where the South Carolina case is listed. I'm going to zoom out so that we can see the South Carolina listing. Would you agree with me here that South Carolina is rated as average 3 according to this data?
I do agree with that, yes.
Do you also agree, though, that there's no correlation between the date when the ROE was awarded and the ROE ranking?
So is your question on this exhibit, is there a correlation between, oh, that's a good question. So the ranking, I believe, is the current ranking at the time the exhibit was created, if that's your question.
So this ranking doesn't tell us anything about what the RRA ranking would have been at the time the ROE is identified on the sheet and the date in which they were entered, what that was.
I disagree with that. I think unless there was a massive switch among jurisdictions, I don't know that it would change all that much. But I do agree with you. There could be somewhat of a change.
But you agree with me that South Carolina has had a change in its ranking.
I agree with that, yes.
So it's hard to draw any conclusions, I think, about the return on equity and what that return on equity means looking at the RRA ranking that you've provided when we don't know what the RRA ranking was at the time that return on equity was awarded.
I don't agree with that. I think large changes in rankings from regulatory research associates are infrequent. So if your question is, would these results be materially different? Would they lead us to a different conclusion? I don't know that I necessarily can agree with that.
Mr. Havert, when we continue to look at this, page 2 of Exhibit 2, there are 36 RRA rankings that you've included in Tier 1.
Yes, that's correct.
There are only 12 in Tier 2.
There were 12 that fell within Tier 2, correct?
Tier 2 as you've defined it. Tier 2 is not an RRA description.
The middle third, correct.
And there are 23 in the bottom.
In the bottom third, right.
So of the 71 results, more than 50% of them were allocated into Tier 1.
Slightly more. And again, that's simply by virtue of the cases that were filed.
But if we were to move, I'm subject to check, the approximately 20 cases where entities were rated as average 1 into Tier 2, would that impact the calculations that you've done in Exhibit 2 for the mean and the average, or for the mean and the median?
I'm sorry, can you repeat that question?
I can. I believe, subject to check, that there are approximately 20 of the 71 cases where the RRA ranking is average 1. Would you agree with that, subject to check?
Okay.
And if we were to allocate those 20 to the middle tier and then recalculate the mean and the median, those numbers would change.
Sure, but again, I'm not entirely sure why you would do that, but if you did, okay.
And so then you have relied upon, I think, this exhibit in your rebuttal to indicate that, turning to page 90 of your rebuttal, that because of what you see through this analysis, that your recommended range of 10.25 to 11 is consistent.
Yes.
Explain to me how you've drawn that conclusion.
If you look at the fact that South Carolina is now average 3, it's in the bottom third, it's a recent change. If we assume that from an investor's perspective, the predictability, the consistency of a regulatory environment is important to them, and that investors look to the Commission's long-standing practice of being credit supportive, then I think we would probably be looking toward the top third results. That is my point.
What among those top third results would you be looking at to support your range of 10.25 to 11?
Well, I think if we were to look at the either the mean or the median, 9.95 to 10.55.
You mean the maximum?
Yes, the maximum. Thank you for pointing that out. The certainly roughly, call it 10% to 10.55%, to use a term you used earlier, overlaps my range.
So are you saying that you believe the maximum is more indicative or the mean and median are more indicative?
I think they're all indicative. I think that's the point, that, again, these are numbers that are not precise. The cost of equity is, again, unobservable. We have to look at this type of data and draw conclusions from it and from other data points.
Thank you, Mr. Havert. Mr. Sullivan, I have just a couple of questions for you, but I'm going to need to get my papers in order, so give me just a second. Mr. Sullivan, I want to focus primarily on your rebuttal testimony.
Okay.
You would agree with me that you are not an expert on return on equity, wouldn't you?
Not an expert. Agreed.
So if I draw your attention to page 5, line 14, you indicate there that you've compared the current authorized ROEs for utilities in the southeastern United States.
Correct.
How did you determine what you were going to include or not include?
I focused exactly on what I described the table is intended to summarize, which are vertically integrated utilities located in the southeastern United States, and tried to focus on orders over the last 5 years. We also tried to focus on general rate case orders as opposed to limited issue riders.
Do you know when the order in the Georgia Power case was entered?
I do not know when it was entered. I just have the year of the order, 2013.
That would have been more than 5 years beyond the scope, right?
Yes, it could have trickled into 2012.
Well, but I mean, if we just go 5 years back from 2019, and you would have filed your rebuttal testimony in this proceeding in 2019, is that correct? And so 5 years back would go to 2014?
Yeah, depending on when exactly that was, it could have been 5 and change.
Okay. But you agree with me that 10.95 is the highest ROE among the set of utilities that you've included?
It appears that it is.
And obviously, if we excluded that authorized ROE from the calculation, the average you've conducted, it would make that average lower?
Mathematically, yes.
Mr. Sullivan, have you seen the letter that was filed by ORS in this proceeding containing the Plan B?
I have not seen the letter, but I have heard about the general intent of the letter.
You understand that it proposes as a Plan B a 9.76 ROE?
Yes.
And has the company taken a position on that?
No.
Does the company have any explanation for why it's seeking a 10.5 ROE in these proceedings when we look at the 9.9 that was awarded in the North Carolina proceeding?
I would say the company settled the 9.9 in a partial settlement case, and so given the totality of all of the things involved in that settlement, and in recognition of everything else that it intended to accomplish, the 9.9 is the result of that case.
I don't think I have any further questions.
Thank you.
Gentlemen.
Okay, we're going to take a short break before we go on to ORS.